Hello, my name is John Mayer, and I'm the Executive Director of CALI, the Center for Computer Assisted Legal Instruction. The video you are about to watch is from the annual CALI conference held at the University of Michigan School of Law in Ann Arbor, Michigan on June 4th and 5th, 2026. Most U.S. law schools are members of CALI. CALI publishes over 1,400 interactive tutorials that teach the law to law students. Faculty can also use LessonLink to create formative assessments using CALI lessons. CALI publishes casebooks by paying law faculty to write and review books that can be adopted in many courses in law school. These books are free to download from our website, or print versions can be purchased at near cost. You can download the PDFs or even the Microsoft Word versions of most of our books and add your own commentary before distributing to your students. $300 casebooks are a thing of the past, and adopting one book from CALI saves you more than your entire institutional membership. If you would like to learn more, email me at jmayer@cali.org. I would be happy to visit or zoom into your school to talk about CALI.
Okay, I guess we're starting. Good morning. My name is Heather Simmons. If you're looking for Jordan, we switched programs. Hers is later this afternoon because she's teaching right now. I have a confession to make. This is kind of the anti-AI presentation, but I use Notebook LM. I wrote my whole presentation, and I got to the end and I'm terrible at conclusions. I want a really strong conclusion, so I uploaded my slides to Notebook LM and said, can you help me write a stronger conclusion? And it did, and it's awesome. And then there was this little button that said, experimental slides. So I pressed the button for slides, and it made me a bunch of slides. And some of them were awesome, and some of them were a little weird. So you'll easily be able to tell which ones are the ones. This is a Notebook LM. Why old-fashioned legal research is the ultimate defense in the generative AI era. Does anybody follow Aaron Dinnan on Instagram? He is a Duke. I thought he was a tenured professor. He's an instructor. He's an English major, but he teaches entrepreneurialism, tech startup, learning to fail. And a couple of weeks ago, he bought all of his students a book, and he's making them read a print book. And at the beginning of every class, he has a question as the students are coming in, and he films it, and he says, when was the last time you read a print book? And the answers ranged from 18 hours ago to third grade. So some people were upset to have to read a book, but I maintain there's still value in print. So a little bit about me. Every school I ever went to is within walking distance of this building, except law school, where I went to Wayne State. I had to go to the Wayback Machine to find the appropriate W for Wayne State because they rebranded in the years since. I'm a Tartar. They are now the Wayne State Warriors. So lots of change. So in 1985, personal computers were a brand new idea. We had one Lexus terminal and one Westlaw terminal. It was a terminal. You had to dial up the mainframe computer in Ohio and Minnesota. You had to sign up for a 30-minute appointment, and that's all you got. The second-year law students gave tours of the library, which is how we learned research. And they're law students. They make stuff up. And so when I was there as a reference librarian, the students would come to the desk, and I'd say, no, they'd say, I'm doing this thing, and I'd explain it to them. They'd say, no, my second-year tour guide said it's like this. And they're like, no, that's not how Shepard's works, and they wouldn't believe me. It was terrible. And my Bill Gates moment was, will we ever be able to do this from home? And I said, not in my lifetime, but probably in yours. Fast forward 4 decades. I'm now at the University of Georgia. We have 6 sections of 1L legal research taught by librarians. We don't have well, I won't go there. It's a 1-credit course. It was 10 weeks of a 14 semester. It's now 10 weeks of a 13 semester. And I think that's going to screw everything up because we used to finish right when they were getting their open memo assignment that they have to do their research for. And I don't think that's going to work this semester, but we'll see. It's graded on the 1L curve, which of course we hate. We teach the same topics in the same order, 4 assignments and the same final, but beyond that, everybody teaches their own way. The thing that makes me crazy is we give the first graded feedback they get in law school. Legal writing gives lots of feedback, but it doesn't have points or grades on it, so you really don't know how you're doing compared to anybody else. Our short-term goal is to prepare them for the open memo, and our long-term goal is to teach them enough to keep going on their own, because that's the only required research course there is. Research will be a next-gen bar subject. It's not really research at all. It's hierarchy of authority and analysis, which are the 2 things I really hate teaching. My philosophy is my job is to find relevant legal materials, and then it's the lawyer's job to figure out what the authority is and all of that stuff, but I will do it if I have to. Our law school is pretty reasonable about Gen AI. The thing we really like is that the dean sees the library as the center of expertise for AI and how it works and what to do about it, so we really appreciate that. In our class, you're allowed to use it either completely or when permitted on assignments and on the exam, as long as you tell us and you provide the prompt and the transcript. There's a law school-wide committee working on this. They just changed the requirements to have a required AI class before they graduate. And we're having a law library retreat next week to figure out how to teach AI in our 1L class. So I would be able to tell you more a week from now. I would really prefer not to teach Gen AI at all in the first 10 weeks of law school because you don't know what you're looking at. They have 2.5 more years to learn Gen AI. And in 10 weeks, I have a lot to cover, and I don't have time to teach a lot of detail about Gen AI and how it works and how to evaluate it. Who knows where it will be 3 years from now? And if they don't understand traditional legal research tools, they can't evaluate when AI went wrong. The saddest thing that happened a year or so ago, I had a student who used AI on the exam, and they said, here's my AI transcript. It gave me the wrong answer. I'm going to ignore it and do my own thing. It was the right answer. Broke my heart. So artificial intelligence is a fancy name. Back in the 50s or whenever it started, they almost called it applied statistics, which is really what it is. It's just a lot of math, but artificial intelligence sounds fancier. But everything it does is hallucinated or confabulated or made up. It writes plausible English sentences. It writes stuff that sounds good, but it really doesn't understand what it's doing. And the biggest problem is you can't recognize a hallucinated citation by looking at it. There was a thing at AALL last year where somebody they made up hallucinated citations, and it was a law librarian, so they had made up a citation where the Federal Reporter series and the date didn't match. And so we could tell right away that it wasn't a real citation, but AI doesn't do that. It makes good citations that look perfectly valid, and all the stuff lines up, and it's either not a real there's nothing there, or the thing that's there isn't the thing it says it is, or it doesn't say what AI said it said. So you have to read the cases. Lawyers have been citing cases they haven't read all along, but now we can prove it. A firm grounding in traditional legal research is the only defense against AI hallucinations. Print resources and their cognitive metaphors hold unparalleled value in the digital age. Read the cases. Thank you, Notebook LM. You said that beautifully. Tanya Thomas wrote this amazing 4-part article that I highly, highly, highly recommend. I wish I had written it. It says all the things I wanted to say. The chicken McNuggets of legal research. I invited her to give this presentation with me, but she recently relocated and she's not willing to come back. So here I am by myself. My 2 favorite quotes are, we've moved from farm to table to factory farming to ultra-processed foods, where we have no idea what we're eating. Everything on the screen looks the same. Everything is just content delivered through identical interfaces. And that is the problem with online research. Thank you, Notebook LM. everything looks the same. This is my very favorite slide it gave me. This is exactly what I'm trying to say. You need your analog cognitive model as the base, and the digital tools on top, and the generative AI on top. And if you don't have all of it working together, you're not going to understand what you're getting. You have to go through the foundational layers to get to where you're going. So that's the rest of what we're going to be talking about today. Indexes, tables of contents, and mental models. My whole scholarship, my whole career has been the value of print in the digital age. So, index. If you're a young person and you've only ever done research online and you've only ever used Google, you've probably never used a print index. And you don't know what a cross-reference is, and you don't know what guide words are. And that's a problem. So the thing I like to teach an index with is the Blue Book, which has a fabulous index. And I have an assignment where I have them pair up and I give them all a word to look up in the index and then tell me where it sent them and what they did with it. And it's a good way to show how a cross-reference works. So you have to understand that if you look under case history under the letter C, you have to turn to H to find history of cases. And if you've never done that in print, you may not understand how to do that. So here's an example. The word agencies, if you just open the Blue Book and look at agencies, you may not realize you're in abbreviations. And so what you really want is agencies administrative, see administrative agencies. So page 93 is completely different information than the abbreviations, adjudications, arbitrations, reporters, and reports that you get under the actual heading for administrative agencies. So the indexes are a little tricky, and you need to learn to use them. And then the challenge is trying to find them online. Lexis does not make it easy to find your index. You have to start typing really slowly. If you type United States, and then it'll give you the index to click on, but it's harder to find. But they do have a really good table of contents on the site. So my classic example is normal people say statute of limitations. The term of art is limitation of action. And here it is on Westlaw, same thing. So an index takes you from the word you know to the word the source uses, and that's the value of it. Okay. The problem with searching online, especially statutes, is it dumps you in, it takes you directly to a section. And it's a very specific section, and it may sound really good, but you have no idea where you are. If anyone's interested, my map is a picture of Hell, Michigan. We have hell and paradise in Michigan, but you don't know where you are. So that's why you need the table of contents. You need to back up and see your table of contents. And then we have the mental model of a library. Back in the day, you had to use book research, and you had to figure out what book you needed, where it is in the library, walk to that shelf, look at the volumes, figure out which volume you need, pull it off, and turn the pages until you get to the section you're looking for. And by then, you know where you are. It's also easier to read online, read on print. Even young people say they prefer to read print books. A lot of times it's a different cognitive thing. I wish I had time to show this whole video. It's my very favorite thing on YouTube. It is the medieval monk who has gotten he scrolls his whole career, and he got his first book, and he can't figure out how to work it. And the IT guy has to come and show him how to work his book. This is another article I wish I had written, Mapping the Achieved Values of Legal Reference Books onto the Digital Future. Elizabeth Outler is saying, all these things, these table of contents and index and page markers and guide, all the things that help you use a book don't necessarily make their way into the online world, and there may not be an online equivalent to help you find the things you're finding and use the book you're trying to use. And this one broke my heart. I was writing a research guide on federal income tax, and I went to the print cumulative bulletin, and this was right on the front page. They're announcing that since they're digitizing the Internal Revenue Bulletin, they're not going to, it used to come out 6 months at a time, and now it's online, you just get all of it. And given that the electronic version can be searched electronically, there's no reason for an index, so we're going to stop creating it. Broke my heart, because everybody knows if you can search the full text, that's going to give you everything you need, and you don't need any other index or finding tool. Sorry, I'm being sarcastic. So let's talk about some specific sources. This is called a visual syllabus. When I was at Illinois, I went to the Center for Innovation in Teaching and Learning, and the instructional designer said, draw me a picture of the big idea of your class. So this is it. We're making coffee. We put the primary sources in, the container is the American legal system, and the filter is secondary sources and finding aids, and what comes out the bottom are the relevant legal research materials you need out of the thousands that are available, that are the ones you need to answer your question. So let's talk about some specific examples. My hypo is age discrimination. A guy works for a company, he feels he's being discriminated against on the basis of age, and he comes to you to find, do I have a cause of action, and what are the statutes and the cases, and what do I need to proceed? This is the statute somebody gave me. Take a look and see if you can tell why I gave them 0 points for this answer.
What was the question?
Age discrimination. Sounds good. The hint is, it's Title III. Cindy.
How the age discrimination in back in 1967, and why aren't we citing?
Well, they should be citing 29 USC 63.3a, but they gave me 3.411, which is wrong. This is why it's wrong. Title III, if you'd gone to the book, only applies to the president and people who work for the president. So it's completely irrelevant to our regular guy who works for a regular company. This is the problem. It dumps you into a section that sounds good that's completely wrong. So here's the table of contents. So if you were looking at that section and you backed up to the table of contents on Lexis or Westlaw, this is what it would tell you. President, extension of rights, employment discrimination, family and medical legal. And it's also the thing about you need to look at the definitions. Who's a covered employee? That's a clue. So all of those things are better in books. Who's heard of the parallel table? It's my favorite source. A lot of people have never heard of it. It saved my life early in my career when regulations weren't online yet. It is a table in the CFR Finding Aids Index volume where you look up your USC number and it will tell you what the regulations are under that number. And actually you can do United States Code by title and section, you can do statutes at large, you can do public law, and you can do executive orders. So it's a fabulous table that takes you right to the regulations if you know the statute. So you can find it in the print CFR, which Federal Repository isn't giving out anymore. My library got special permission to keep our print CFR, and I am very, very happy. If you have USCS, which we canceled, it's in the index volume. It's in the volumes at the end of the set. And it is on govinfo.gov. They have the CFR index and finding volumes digitized, and it's on page like 963, so you have to scroll to the very end. But it is there, and it's my favorite. So here's an example of the parallel table. 5 USC 301 just says heads of executive departments get to make regulations. It's a very general set, but this is what it looks like. You get your USC section numbers on the left and your CFR parts on the right. Favorite source. You can do this online, by searching the Enabling Act section numbers in the credits field. So this is CR parentheses 44 plus 31506, which is the way to search a statute, is to use the +3 connector. So this is Westlaw, and this is about the publication of the Federal Register and the National Archives. The other problem is that statutes and regulations look exactly alike. How many people have had students give them a CFR instead of a USC, right? It's really easy to do. I chose this example, the Wild Horse and Burro program, because the criminal provisions in the statute look just like the criminal provisions in the CFR. I mean, even the words are similar. But unless you notice that little tiny CFR way up at the top of the page, you'd never know that you're in the wrong place.
Can I ask a question?
Yeah.
So going back to the parallel table of authorities, one of the things that I taught my students is if you're in like a statute, look at your citing references and whatnot.
Right, right.
But I've never done an actual comparison between the parallel table and then what shows up in the citing references. Have you ever like dug in and looked to see, is it largely similar?
No, that would make a really good article. Somebody should do that.
Okay, buy tomorrow, please. Right.
I haven't done that, but I have noticed that there are times where in the statute, the citing reference doesn't list a reg that is like very obviously related to that statute. And my guess is that the parallel table would have it. I've never looked, but I bet it does. I bet it's more accurate because I bet it is more human created as opposed to algorithmically created.
Yep.
You
Give
would
me.
think that, no, you wouldn't because they're not there. But you would think that a legal publisher would be like, oh, that exists.
Let's leverage it. Yeah.
Let's make it behind
Let's-
the paywall because we put it as our thing.
And let's make sure our stuff covers it. Yeah, wouldn't that be nice?
I guess they don't do it because they can copyright themselves.
Maybe. No. How would you know?
We'll be looking forward to your articles.
So in print, you can't confuse the USC and the CFR because USC is a burgundy hardbound and CFR is a bright colored paperback. You can't mix them up very easily. I mean, you could, but it's not hard. So again, this is my notebook LM giving me the comparison. Without analog grounding, a federal statute and an agency regulation look exactly alike. Researchers lose the instinct to weigh differing authorities. So cases. This is my favorite key number. It's about whether the heading of a statute is part of the law or not. And I'm from Georgia, where we have the official code of Georgia annotated, where the annotations are part of the statute, although there's a bill. There's a bill right now to say the annotations are not enacted, but it hasn't passed yet. But it makes me crazy to say annotated codes are always unofficial, except for Georgia. They were lazy. They just adopted the whole thing, lock, stock, and barrel, when they bought it from the publisher. But this is my favorite head note, a key number, because it's about the typography and the printing of statutes and whether the heading is part of it or not. And if you've never really looked at a print digest to see all the head notes in key number order, it really helps you understand what the heck a keynote and I'm getting it wrong, a head note and a key number are and how they work. So this is the same thing online. I'm using Michigan examples here, but it's statutes, construction, extrinsic aids, ancillary provisions, titles, headings, and captions. And that's the other thing about key numbers is when you're online and you see the key number, it would be statutes, titles, headings, and captions, which in this example makes sense. But a lot of examples, the topic and the specific thing, if you don't have the rest of the outline, there's one about, Michelle found a fun case about geese. Someone was attacked by geese. And the key number is animals something. And if you don't have all the intervening outline, you don't know why you're getting that particular key number. So I always try to teach people you need to explode that part, which of course I haven't got an example of. but it's important to see the whole outline of the key numbers. Teaching Boolean logic. I love Matt Margolis. I really miss Twitter. I won't say that man's name, but he killed it, and I'm really mad. But this is one of my favorite Venn diagrams. Matt is, I guess he's on Blue Sky now, so he's a really good follow. But as of course, it depends for both accountants and lawyers. So Amy Taylor is a colleague of mine. I love her dearly, but we violently disagree on this topic. She just published this article, and unfortunately, because the statistical analysis takes a long time, it's pre-Gen AI, but she compared natural language versus terms and connectors, and had a bunch of people do searches with the different styles of searching, and then compared the results she got, and she decided she's not going to emphasize terms and connectors as much as she used to, because she needs to make time in the curriculum, in the syllabus, to teach Gen AI, so terms and connectors are the things that she's losing. And I violently disagree with this. I think terms and connectors are more important than ever. My students are completely confused by it. I had math in high school. It was called intersection and union, and we did Venn diagrams a little bit, so it was a concept I was at least had heard of, but my students are completely baffled and mystified. So I do, Michelle found this. I don't know where you got it from, but I borrowed it. We create mythical creatures using terms and connectors. Because everybody's read Harry Potter, everybody's read Rick Riordan, they know what mythical creatures are, and it makes sense. So I give them the mythical creature, and I give them a bunch of words, and I say combine all these words with Boolean connectors to make the creature. And Michelle did an even better example. When they're foreign students, she goes to the country and looks up their folklore and gives them a mythical creature from their country, which is very cool. So this is a hippolectron, which is a horse rooster. So I'll give them a hippogriff, and I'll say horse, eagle, fish. And so they have to say horse and eagle, not fish. Or I'll give them an Ophiotaurus is a bull at the front and a fish. It's like a mermaid bull with a fish tail. And I say, bull, serpent, give me synonyms for bull and serpent for the oars. And we have a lot of fun with it, and it seems to help them understand. But why should we continue to teach Boolean logic? Why am I so passionate about this? Number one, if you can't translate your issue into a Boolean logic statement, you don't understand it well enough to start researching. And you need to go back to the person who gave you the assignment, or you need to reread the hypothetical to make sure you really understand. It's about relationships. Who are the parties? I don't want the parties, I'm very picky about issue statements. I don't want party names. I don't want plaintiff and defendant. I want customer and business. I want neighbor and trespasser. I want the relationship and who they are to each other. And that's how you write your issue statement. So if you can't do the Boolean logic, you're not ready. Number two, it's really cost effective. If you do your big search, if I do products liability as my search, and then I search within for the kind of product liability I'm looking for, you can do variations on that all day and stay within that universe, and it's not as expensive as a new search every time. It's the only way to search field searching. It's like Control F on steroids, because you can have more than one word and you can have the relationships between them. So that works really well. I really like field searching. My two favorite fields on Westlaw are Syllabus Digest and who's ever heard of words and phrases? Oh, good. When it was in print, it was my very favorite set. It doesn't work exactly the same way, but it is now a field. So what that will do is search for cases that define your term that you put in your words and phrases field. And my law firm librarian friends tell me that the summer associates who use Boolean logic are the most skilled legal research, and they use Boolean logic. And they're the people who are really good. So these are the reasons I'm still going to emphasize Boolean logic. I don't know where I'm going to fit Gen AI stuff. We'll figure that out next week. Cindy.
Okay, I have a question for you about number one.
Yeah.
So the students
Right,
Like, okay, family law, let's like, as general as we possibly can.
right.
But, so, is there like a before, like, how do you jive that with the students who still need to learn enough to understand the issue?
Well, if your hypo is well written and you don't put terms of art in it, if you just describe it in normal human words that everybody uses, you should still be able to do this. And hopefully that will take you to the bizarre terms of art that lawyers use. But I agree, if you still can't understand it, then you need an encyclopedia or a journal article or something. The mantra of 1L legal research is start in secondary sources. Always has been, always will be. So the 4 pillars of Boolean superiority. Thank you, Notebook, LM. The cognitive test, I wouldn't have thought to call it that. That's if you can't translate it. Precision, cost effectiveness, and employability. I also tell my students when we're doing regulations, law is all about words and what they mean. So I'm very picky about using the right word for the right thing. And when I'm teaching regulations, I say, if you're in a job interview and you can use to promulgate a regulation correctly in a sentence, it will tell the person interviewing you that you know more about research than they do, and maybe they will hire you. So this is the conclusion I started with. A firm grounding in traditional legal research is necessary to use generative artificial intelligence effectively. And print resources still have value in the digital age. This is what Notebook LM, oops, it's not an LLM, it's just 1L. As we navigate a digital information universe, we must recognize that traditional legal research skills are not relics of the past. They are the essential gatekeepers of our professional future. To effectively use Gen AI, we must move beyond ultra-processed research, the chicken nuggets of the screen, where every source looks identical, and return to farm-to-table understanding of the law. A firm grounding in traditional methods using print index for conceptual links and tables of contents as roadmaps are the only way to maintain the context necessary to determine if a statute even applies. Without these foundational skills, we cannot recognize when Gen AI confabulates plausible but false citations, and we must actually read the cases. Ultimately, our ability to translate complex issues into Boolean logic remains the ultimate proof that we truly understand the issues we are researching. And doubling down on these foundational skills, we ensure that as the technology evolves, our authority and analysis remain unshakable. Thank you, Notebook LM. So one of my analogies for this is back in the day, is there anyone here who's old enough that they had to do book research fall semester before you got your Lexis and Westlaw password in January? Yeah, that was a thing. And I'm thinking, I would like to go back to that. First semester of law school, no Gen AI. January, you can have it. But it sounds like from everything else I've heard this week, they're going to use it regardless. So we might as well accept it and make allowances for it and try to teach enough foundational research that they can evaluate the results they're giving. Yes?
Well, yeah, I mean, I think if you had had access to like your Westlaw password back then, even though you were supposed to be using print, you probably would have, I mean, some people would have definitely.
You know, if you had a friend who's a 2L who would share their password,
Right.
I'm sure that happened.
Yeah, we don't have like a mechanism to cut that off. And that is a challenge because it's hard to get them to want to care about these foundational things when they're like, well, it doesn't matter because I have this other thing that'll do it for me.
Right.
And it's hard to help them understand. I actually do want you to be a user of these tools, but I want you to be like a power user, and you'll never be a power user of those tools if you just don't like sit with me for like a couple weeks first.
Right.
And I don't know how to get them to
Understand that. It's a problem. Yes?
I'm a newbie. Hi.
Welcome.
Thanks. But even my interaction with 1Ls, and I'm here to make sure I haven't lost the plot. I'm like, oh, I better make sure I remember this. In my conversations with 1Ls, the ones that would only use one electronic researcher versus the other, I'm like, well, let's take a look at why. And I just keep going back to the why. So, since you're explaining it to me, I'm like, oh yeah, that makes so much sense. Why didn't I think of it that way or whatever? But I
Right. Right. Yeah.
I think it really comes back to the fact that everything is based on the print,
Right.
So
We have 200 years of print publishing before there were ever computers.
that's all you do. Then the life experience of all of the new students, they were in kindergarten handed a tablet, right? So these are folks who have a completely different life experience than I had.
Right.
Maybe we were but so they have only touched tablets. When we get to teach them certain things, I have found that citations are baffling to 1Ls now, where we touch the paper, we touch the books, we understand what a volume is in a page. I started to realize this disconnect between my life experience and theirs a few years ago, and I brought them to the library one day, and it was the end of the semester, and they all stood there like this, and they said, we have to touch books, and I was like,
Mm-hmm.
touch books. So I moved it to the first week. I now bring my students on the first day of class to the library, and we do a citation exercise where they have to look up 3 citations, so that now, from that point forward, we can say, that was the volume, and this is the page, and a simple concept like that is actually making sense to them.
Exactly.
So I think that the real disconnect is the life experience of the folks who use the print
Mhm.
and the electronics, and now we have folks who are 100% electronic, and we're trying to connect
Bridge
those
the
dots.
gap.
So that's where I'm at. Sorry.
Julie,
To say all that.
in your presentation, you cited Alexa Chu's citation literacy, which is another article I wish I had written. There was a Yale citation symposium that I wrote an article for, and I was so excited. I had my seminar paper accepted to Yale Symposium, and it was during COVID, and I didn't get to go. But that was my analogy. Is students see, when you click on the link, it's like a wireless passkey. It's just a random collection of characters, and you click on it, and it takes you somewhere. And we all know there's a wealth of information in those numbers and abbreviations. We can tell you the age, we can tell you the jurisdiction, we can tell you the authority. It's all there in the citation, and we need to teach them how to read it and what it means. Yes?
I have to steel myself with this.
Sorry.
As a big proponent and fan of artificial intelligence and so forth, please bear with me.
Absolutely.
There's something I fundamentally agree with about what you're saying, but also something that I'm fundamentally skeptical of, wondering what your thoughts are. So I fundamentally agree that it's necessary to have a mental model for how the information is organized. And someone with a mental model will better understand what information, and how the information itself is related to other information
Yeah.
and so forth.
Where it comes from and how it fits together.
Yeah, so they'll better understand that than someone who doesn't have any kind of model. But is the mental model of print organization really the best one, especially these days when there are alternatives? So you'll say,
Give me an example of an alternative.
So there are various ways of representing data other than this particular linear way that is enforced by the way print works. So the one that occurs to me is a knowledge graph. And a knowledge graph is not hierarchical. It allows concepts, not just concepts, but things that represent items like cases, statutes, and so forth, to be placed in arbitrary relationship with other such things. And I think, this is intuitively and probably, indisputably from a cognitive science perspective, how knowledge is organized, at least mentally.
That would make an excellent paper. You should write that.
Well, the thing is, I'm sure this paper has been written dozens, if not hundreds of times.
It has not, and I can respond to it.
Well, if I might.
Yeah, let him finish.
So, I think that even print has always had to make concessions to this. If knowledge were really organized in the way that is most convenient for print publication, we wouldn't even have such a thing as a cross-reference. We wouldn't have things, such as footnotes. And the fact that we have these things is a concession to the fact that knowledge is not related to other knowledge volumes on the spines of the volumes and so forth. And it is better to understand that than to understand nothing. But, take something like the whole key cite system. So that is extremely valuable. And it's extremely valuable because it gets at the idea that knowledge is related to other knowledge as a graph. And the graph relationship is something that is increasingly possible to represent because of technological developments. And it's also something that is really amenable to being searched in a kind of a naturalistic way. I mean, I'm very sympathetic to the what you were saying about being familiar with Boolean logic. I took a fair amount of logic. I'm a philosophy person in a previous life. And yet, concepts have this kind of, family resemblance relationship to each other. Things that will be obvious under one description will not be obvious on another description. So, a sort of canonical example of this is the morning star and the evening star. It doesn't sound, obviously wrong to say something like, well, the morning star is not the evening star, except that the morning star and the evening star are both different names for Venus. And so, you could represent this with Boolean logic, but you would have to know more about it to do that. Whereas if you did something like a semantic search, which is also something that is possible because of the rise of AI, you would need to do something like that. And so my point generally, though, is not that there are shortcuts, although there are, and that means something. It's that perhaps there are other mental models that are increasingly available now. And I wonder if there is an opportunity cost to teaching the mental model that is suggested by print publication.
Fascinating. I think you should write that article. Cass.
So, I think to some extent it depends on the question, which is largely the answer to most things. And I think you have to, for example, statutes. When you think about a knowledge graph, you have to determine what links you're making between each one, right? The citation and the strength of citation. That'll completely erase the likelihood that you'll trace from a statute to the definition section. Example contents, that wouldn't be the case. They are naturally related just by their existence in this section and their citation in its form. And so what ends up happening is it can be overridden by its reference to CFRs, its reference to other statutes, especially if you think about a statute like something like discrimination that's going to be referenced, I don't even know how many times within this USC to it, where everyone just refers to it by reference instead of saying discrimination again here. And so I think to some degree you have the mental models designed to a certain purpose. And so you have to tell them about the book and the understanding of a book and the table of contents because the relationship that you want to display is just already existent in a table of contents. You don't need to try to create a knowledge graph to replicate the table of contents that's duplicative. Now, to associate it with other things, generative AI is using semantics to try to make some of that connection. But the problem there is a language one. So we find that students who don't know the law very well use language that when it goes into the RAG to find the cases that are semantically similar are often much lower level cases that use much more like blasé language. And then that is being added to their search, which actually makes their search trash. Because then their results are, here are the 12 district court cases about your First Amendment issue instead of the foundational ones. So there's something to be said about understanding even the language, which is a different model from the knowledge graph itself, and that language comes from sources that, thesaurus and things like that, and you can try that online, but there's already right? So there's a need to talk about the print model because some of it already exists as a way to reference and help people guide themselves to it. Things like the index that gets you to the right words, things like Black's Law Dictionary, which will help you just try to figure out what language to use, as opposed to trying to recreate it all inside of a search. And then once they have the right language, the right areas to search, when to use what tool and how, you can apply those different things. And so even like Wes and Lexis use knowledge graphs behind the scenes, right, or relationships, but their relationship thresholds and weights are so different but those related sections didn't come up in my search.
Yeah.
And just switching my search is not gonna, right? But most students will just
And-
keep reading down the line. I'll read this section, then I'll read the article that showed up in my results, and then if they understand the print model, they'll understand I can find related group things that are organized already through a reference instead of
And-
depending on the
Yeah.
contract. So I think there's something to be said for like a mix.
Yeah. Plain language in the law is a thing, but we're not there yet. There's a lot of hidebound, old-fashioned terms that you still have to work through. In the back.
I just wanted to say, like, people remember concordances?
Yeah.
Woohoo!
Like, I feel like that's a knowledge graph, and they're a close cousin of an index.
Yep.
And to your point about opportunity costs, the structure that has developed around these systems, these mental models, has been honed over hundreds of years. And so although there might be, everyone wants to build their own ontology and their own this and that, there's a proven nature to these that I think works really well as a starting point in those first several weeks. And then I think once you have that foundation, they're very much then the world is your oyster.
Right.
But there is an opportunity cost to reinventing. So I think you're right, there's potential. But I think you're right. We shouldn't throw away
We're all right.
hundreds of years of
Well, if I might, so again, I don't think that the relationships that are represented in traditional things like indices, tables of contents, and so forth. I don't think that those are useless by any means. Those are very important. But I think it's worth reflecting on the fact that all of those relationships can be represented by a knowledge graph. And there's a reason that West, and Lexis use knowledge graphs behind the scenes. And it's for that, and that is the reason. And I think it's also worth considering, I think that the extent to which people struggle to learn traditional legal research speaks not to the uselessness of those things, but to the maybe perhaps non-intuitiveness of it.
Well, let me reply by saying this back to the beginning and the next gen bar exam and authority and analysis. The law is inherently hierarchical. District court, appellate court, Supreme Court. And you have to understand those relationships to be able to do anything. There were more hands. Somebody all the way in the back.
Yeah, so I think, well, we could say one thing that came to mind with this discussion is not about sort of the abstract knowledge graphs and mental models, but specifically about sources that are not actually framed first. One thing that came to mind is practical law, which has features that could not be replicated. Which is, I just wanted to throw that in there as a more concrete example of non-print-based sources.
Thank you.
It's not to say that the right are not useful or not. But the question that I had
Yes.
was about, so given all this, what techniques do you or anyone else have for helping students understand these things? I'll say one thing that worked for me, as I taught, was they were told not to use 1L or not to use AI. Search, but I think they were, took us seriously enough and were motivated to learn enough that they didn't just. And one thing that was to say, okay, you've got to grill with this problem. Now let's ask AI what it looks like. And they were able to immediately, I asked them to sort of consider, how would this have been helpful at the start of your research? How would this not have been helpful? I think that kind of drove home for them. I was curious if anyone else has any useful techniques.
There was a hand in the front. Yeah, go ahead.
This is sort of going back to the discussion before, but I think possible to distinguish questions that are being asked. But we're sort of talking about like how knowledge can be organized in the way that is most like inherently functional for cognitive science. But really, what we're talking about with teaching Boolean connectors is what is the way we can teach access to sources that have inherited the model of like indexes and stuff. I mean, it's organized like that, whether it's in Westlaw or in print. And the question is how we're going to get to the statute that is actually going to matter for the case.
Yeah, the hierarchy is built in. Front row.
I like your earrings. I also
There are cats drinking boba tea if you
Ah,
can't see it.
love it.
But yeah, Shay hit the nail on the head, and so did you. But yeah, with students or just in reality in the world, how do you mitigate shadow AI use? You can't just turn them loose. So with what this is also in my mind's eye of like, okay, how can I get them to agree, at least suspend disbelief long enough to rush off
There you go.
to your electronic thing if you don't know what you're doing. Like let's just get you the right tools now.
Right.
So that we can understand the entire context of why you're doing what you're doing. Yeah.
Michelle.
So to answer your question of how I address this, you know, you already tell everything about how I teach. But the last couple of years, I've been taking all the things like, you know, like I think most people, right? I always did, you know, this week we're going to talk about secondary sources. This week we're going to talk about cases. This week we're going to talk about statutes. And, you know, I talk about everything from like, this is how the law is created and published, the various forms of publication, like the things that are the law, and then these are sort of the tools that, you know, the editors provide us, and we learn about each of the tools and we search using those different tools. And I've sort of disambiguated the parts of each of those lectures, and I put them together and I organize them now, irrespective of source, but by like the thing. So essentially, we don't research for several weeks in my class. We're like doing almost traditional legal bibliography, where we're only talking about like how the law is made, the hierarchy of sources, what a citation communicates in librarians' terms, looking at a known citation or a known source. And so like, I'll give them the source, like I'll give them, this is the statutory code. And then we like dissect it and label it, and then all the different things, I talk about those being like doors. Like, what are the doors that would lead out of this citation? We're not gonna go in them, like, but I want you to recognize what those are. And then the second half of the thing, we do like a whole problem over several weeks, not kind of looking at cases and statutes, but organically research. And this year I'm actually starting with AI because I think that's what they're going to do anyways. And so we're going to start with AI, we're going to talk about it, and then we're going to use all of our traditional tools as that process of like vetting, verification, and everything. I don't know how it'll work,
Yeah.
you know, in like November. But it's last time I did the same thing, and then we ended with AI and did it as a review. And I had a really similar experience to Heather, where a lot of people did their own research on the final project, and then they did AI, and they kind of went left, and they should have gone right, and AI gave them the answer that went right, and they said, oh, AI just made stuff up, and they, which I thought, that's like a hard flex for a 1L to be like, everything I knew was right, but the computer was wrong. But so many of them did that, so I didn't think it was helpful, and I also feel like some people probably were using AI along the way instead of at the end, so I might just lean in, I think, this year.
Yeah. My colleague,
I kind of separate that.
my colleague Brandy Ellis in her advanced class has them prompt the AI, leave it running. While it's doing its thing, look up the actual answer in the treatise and then compare.
Yeah.
But I don't know that a 1L is ready to do that. Other hands, goodness. I'm all the way in the back.
One way to appeal, it seems to me, to students on this issue, fundamentally they are coming to us as the tools to manipulate a system on behalf of their clients. That's why you go to law school. If you can't, people who do this, who have done your client a serious language. Best language or the worst language does not matter. Remember, this is the language. Place it.
Easy.
In an ideal world, that's how I'd like to do it. I don't know. I have time to do that in 10 weeks. I have to figure that out. But I'm really struggling with how to shoehorn Gen AI into my 10-week course. Cass.
Depending on
Oh, that's good. So do the print thing in class, and then go home tonight and do this and reflect about what the differences are. That's really good. I like that a lot.
Like a very specific thing, like if
Yeah.
you made them go find a secondary source, try to find that secondary source through Gen AI. Or if you found a case, try to see if you can get Gen AI to give you that case without quoting the language of the case. Like what would searchers have likely done or something like that. And then just a quick reflection. Just
Yeah,
try
that's
to
an
keep it to
idea.
like a paragraph, both for your sake and theirs.
Yeah.
And just,
Yeah.
if they do it every single time, they'll have a continuing record of.
That's a really interesting idea. Yes.
I guess I'm struggling with why this is so complicated, because if you think back to all of the methods that we use for teaching how to write a search, looking for keywords, where we were all teaching them how to look for the who, what, where, when, the legal issue. You're brainstorming in the same way, whether I'm writing a natural language search, a terms and connector, or an AI prompt. And they need to know who their parties are. They need to know what the key facts of the story are. They need to know the jurisdiction. Where did it take place? They need to know what the legal issue is. And if they've brainstormed about all of that and they've pulled out those key terms, the searches are almost identical, really. I mean, if you think about your natural language search should have the same words you could use in your terms and connectors. You're just pulling out those connectors. If it's an AI prompt, you're turning it into a sentence. You know, like we're now adding all of these things. So
Yeah.
I don't see this as being complex. I feel like if we teach the who, what, where, when legal issue, we're kind of accomplishing all
I say that all the time. A well-drafted issue statement makes a fabulous natural language search. So it's learning to draft the issue statement.
I think it comes back
Yeah.
to the who, what, where. Like, are they brainstorming well? And then we teach them all the other methods from there. But anyway, that's just.
Thank you. Cindy.
I think my comment is less about the front lines of like teaching the student
Mm-hmm.
and really more of our back end role as a librarian of being the interview. I think really speaks to Ben's comments and your comments and Cass's comments in that remember the first time I saw Rattle Law and how mind-blowing it was for me to see cases and interconnections between cases represented in a complete and it let me know like, oh, this really is an evolution, right? Like
Yeah.
we're in the middle of the evolution of the representation of ideas in language, and it's complicated. And part of what we need to do is advocate to our vendors, the people who are, trying to represent material and information in a completely different way.
Yeah.
Continue to help them understand how our users are experiencing.
Exactly.
So that they can really get a sense of like, hey, we really need to see, you've got a statute here, but you need some sort of visual representation to say like, go to the regs, go to the secondary sources in a way that it's not being shown right now,
Yeah.
but is
And-
incredibly valuable. And it doesn't discard
Yeah.
Benjamin's knowledge map. I mean, that is what humans have been trying to
Yeah.
do with the index forever.
Don't get me wrong. Computers are amazing,
They are.
but
We need to
they do amazing things, but you've got to have the foundation. When I teach IP legal research, and I tell my students, do I expect you to be an expert patent searcher by the end of this semester? Of course not. But I expect you to be able to appreciate the complexities involved in patent searching, and if you're hiring somebody to do a patent search for you, what do you look for in interviewing them, and how do you evaluate the results they're giving you? And that's the same as evaluating Gen AI results, but you got to have the foundation. Well, that brings us to time. Thank you very much. What an awesome discussion. Thank you, everyone.